Hello everyone, welcome to Emerging Issues in Care and Protection in 2021, What We Have Learnt So Far. My name is Katie Kelso and I am the Solicitor in charge of Care and Protection. The last 9 months have been quite a ride for those of us who practice in care and protection, and it's probably fair to say that for most of us we didn't really see it coming. The case of GR and the cases that followed raised some really complex issues that hadn't really been considered since cases like SL were considered in 2016. For all lawyers practicing in this jurisdiction, I imagine it's probably been an anxious and stressful 9 months, and there remain some significant unanswered questions even as we sit here today. Today I'm joined by two people who have been involved at the coal front and felt the full effects of these decisions. Firstly, we have Kate Bassey, who's a senior solicitor at Legal Aid based in our Wollongong office. And we also have Jennifer Brown, the manager of the Client and Assessment and Referrals Unit at Legal Aid New South Wales. Jennifer is currently appointed to the Guardian Ad Litem panel and manages a number of other guardians that work at Legal Aid New South Wales. And last, but by no means least, we're joined by Greg Moore, barrister at Frederick Jordan Chambers. Some would expect, given Greg's level of expertise, he would have somehow found himself caught up in these cases, but here he is, unscathed today, having watched from the sidelines, and that's why we have him here today, to provide his perspective as an expert, but also as an outsider looking in. So with that in mind, we're going to take you back to where it all began, back to the 16th of November, where judgment in the case of GR was delivered by the Supreme Court of New South Wales. So Greg, this first question is for you. In a few sentences, can you tell us a little bit about the facts of the case of GR?
An appeal to the Supreme Court from a decision of the President, so it's under the Care and Protection Act. A young person who was incapable of giving instructions, so it was allocated to Justice Sackar. Application came before Justice Sackar to discharge the ILR who had been appointed, and in the course of that application, His Honour himself raised the issue as to whether he should appoint a guardian ad litem for the child. His Honour taking the view that the section 98(2)A was mandatory, and ultimately he did appoint a guardian ad litem, and that then led on to the issues that you've just discussed. But in relation to the discharge of the ILR, His Honour dismissed that, and in so doing, he held that there was really no evidence of any wrong action by the ILR or their counsel. But in the course of that, he pointed out that there is actually no power in the Care Act to discharge an ILR. You can appoint an ILR under 99(1). He referred to a decision of Magistrate Blewett down in Port Kembla a number of years ago, where His Honour, dealing with 99(3), which referred to withdrawing leave for representation, said that that was limited to 99(2) and not 99(1). So in many respects, that's no power to discharge is similar to the Family Law Act, but in that jurisdiction, it's there's no issue these days that there's a power to discharge, except perhaps if you happen to come before Justice Wilson, who has delivered a judgment in a matter of Howe and Carter number 2, when His Honour was a Federal Circuit Court judge. His Honour went through the Act, went through statutory principles, and said, look, with the greatest respect to everybody else, there is no power, but I'm just a Federal Circuit Court judge, and it's so entrenched now that it's beyond argument that there's a power to discharge. So I know there's a case floating around in the Children's Court where some poor magistrate's going to have to determine that issue, where the power comes from, whether it's an implied power or whether it is under Section 15 of the Children's Court Act, or whether there's no power. But in relation to the point that has really raised the litigation and the Court of Appeal litigation is the power is His Honour held that it was mandatory, had to appoint a guardian ad litem, and then all the issues then arose where matters in the Children's Court were being adjourned or guardian ad litems were being appointed. At about the same time, the Magistrate Williams delivered a judgment agreeing with His Honour. The other issue was whether there were a party, whether a child is a party to the proceedings. Justice Sackar said yes. Magistrate Williams said that he's obviously right, and then that was a matter that ultimately went to the Court of Appeal, which wasn't decided.
So we might come back to you on that point, Greg, because I think that's probably worth exploring what the Court of Appeal said and also what they didn't say. But just to pick up on what you've said there were some immediate impacts really with the decision that Justice Sackar delivered, wasn't there, in terms of the District Court and Supreme Court? And things didn't quite sort of clarify in the Children's Court for some time, did they? It wasn't until January that His Honour Magistrate Williams delivered the decision of re Oliver. Are you able just to briefly describe what that case was all about and what His Honour said?
Well, it was a young child, and His Honour held that he was bound by Sackar's decision to appoint a guardian ad litem. Guardian ad litem was appointed, and the child was a party. 98-2A was mandatory. Therefore, guardian ad litems were appointed. I gather that there was a practice in the Children's Court. Some magistrates took the view that children weren't parties, therefore they didn't have to appoint guardian ad litem. Some took the view that they did, and with the result being that plenty of guardian ad litems were required for children, and a lot of matters were adjourned. Matters listed for hearing were adjourned pending the outcome. Obviously, the department then became involved and with their legislative amendments, but those matters didn't come through until much later in the year.
So if I can just take you back a step, there were some immediate impacts in the District Court and Supreme Court because, am I right to say this, Greg, there are the UCPR rules and there's the Civil Procedure Act that's often at play there. So am I right to say that the impact was a little bit different in those jurisdictions than in the Children's Court where things were less clear?
That's right, because under the UCPR rules, you become a party, and that was, I think Justice Slattery had appointed, made the child a party in the proceedings earlier that Justice Sackar dealt with. And so as soon as you got the UCPR rules coming in, Judge Dicker took the view that it was the child was a party, therefore it was mandatory. And so once again, those matters were being adjourned. But it adds a further layer into the proceedings, and it brings in this issue where you have children being parties, where you might commence some proceedings and got to join the child or have the child represented in some way. Often the Crown will notify legal aid and seek that the child be appointed as by an independent representative. Even in the Sherwood House cases, some judges in the Sherwood House cases used to take the view that I'm going to make the child a party to the proceedings, partly because I'm worried that if I don't, their rights of appeal might be taken away, and this is such serious consequences for the child, their liberty being deprived, that's a reason. You've got to then appoint a tutor, but the way around that was always to dispense with the tutor.
And Greg, just picking up on that point, that's exactly what happened in the matter of Re Cara number 6. Are you able to talk to the audience about what Her Honour found in that case, which was a Sherwood House matter?
as I understand it, there was an issue after Her Honour made the order that she should have appointed a tutor. Ultimately, she decided that she would not appoint a tutor because it was just another, if you've got the child represented and if you then appoint a tutor, you've got another layer of representation that perhaps is just not required. I think the Court of Appeal picked up that comment by Justice Williams, because if you do have a guardian ad litem and you've got a lawyer as an ILR appointed, I mean, really, why do you need both? I would have thought it's just one or the other. And if you do have a guardian ad litem, really, why then is there a need for a child's lawyer to be represented?
That's the question we've all been asking ourselves for the last 9 months, perhaps.
Yeah, well, that's right. I mean, if you go back to issues like the shrinking funds of the Legal Aid Commission and Justice Baston's point about why are representatives for children being involved in Court of Appeal decisions where it's an administrative law review, and if they're just supporting the department, why are they there? And he talks about the limited funds of legal aid. I mean, both of those parties are paid for by the public purse, but it's what can you add? I mean, sometimes they refer to if the child's got special needs, that might be a reason to have a guardian ad litem above in addition to a child's lawyer. But you've really got to, what are you going to do that's different? Really, I mean, there was a case that I was involved in recently, and I think this was just by per chance that it was an appeal before Justice Kuntz from a decision of the President. It didn't proceed because after about half an hour or an hour, the appeal was withdrawn. But in that case, His Honour had appointed a guardian ad litem, but had also kept the ILR in. And as it turned out, the ILR instructed the guardian ad litem instructed the ILR. And so there was no conflict at all, thankfully. And that's the way it proceeded. But I suspect that's just such a rare case, it wouldn't happen.
I think that's probably a good time to throw over to you, Kate, because you were, as were a lot of practitioners that practiced in Port Kembla and further south than that, probably the date 22nd January 2021 is one that's not going to leave you anytime soon, because that's the date that the Ree Oliver decision was handed down by His Honour. And while we're chatting about why would you add that additional layer, unfortunately for you, there was no point in having that discussion. You were stuck with it. What were the immediate effects for you as a practitioner sitting in that list at the time that decision was handed down?
Thank you, Katie. I'd just like to start off first by acknowledging the traditional custodians of the land on which I'm speaking from today, the Dharawal people, and pay my respects to their elders past, present and emerging. Not only was the 22nd of January the day that Magistrate Williams handed down his decision in Ree Oliver, but it also happened to be our first care list at Port Kembla Children's Court for the year. Due to the COVID restrictions that we had in place at the time, the practitioners were participating by phone or AVL. And as such, there was a tremendous amount of emailing and texting between the practitioners going on behind the scenes. I personally went from inwardly cheering as His Honour was finding that children were parties to care proceedings to groaning when it became clear that the effect of this determination was going to be that Magistrate Williams would be appointing guardian ad litems in all of our ILR matters. At the end of the care list on the 22nd of January, I found myself with orders for the appointment of GALs in 6 of my ILR matters from just one day. There was only one matter where I was able to avoid the appointment of a GAL that day. That was a matter where I was acting as the ILR for a child that had recently turned 11. And I requested an adjournment so that I could meet with the child again and consider whether it would be appropriate to make an application pursuant to Section 99B, subsection 2, that the child was capable of properly instructing a legal representative, and then if so, seek to be appointed as the direct legal representative for the child instead, and as such, avoid the appointment of a GAL in that matter. And I did end up going on to make that application at a later date with the consent of the parties, and my appointment in that matter was changed from that as ILR to that of a DLR.
Kate, can you talk us through the impacts upon the children that were subject to these proceedings? I imagine running a busy list in Port Kembla matters would have been in possibly for the first appearance, for care plans, for final orders. Are you able to share some experiences of what that looked like for those children?
Definitely. There were considerable delays across all matters involving ILRs once orders were made for the appointment of a GAL. First return dates weren't too difficult because we were generally able to have interim issues dealt with first, but then once the order was made for the appointment of a GAL, most ILRs felt somewhat hamstrung until a GAL could come on board and provide them with instructions to consent to things such as findings or leave or to final orders. I did have one matter where I was the ILR that was listed for final orders on the 22nd of January. And the only reason the matter didn't finalise that day was because an order was made for the appointment of a GAL. In that matter, the child was not yet 3 years old. Despite efforts from the Port Kembla Registry to follow up with the panel about the appointment of GALs in those matters that were otherwise ready to finalise, it actually wasn't until May that a GAL ended up being appointed, and final orders were finally able to be made 4 months after they had originally been agreed to by the parties. Fortunately, in that case, there was no real prejudice to the child, as the child had already been placed with the proposed guardian, the maternal grandmother. But the delays in appointments of GALs did hold up the finalisation of a number of matters, and it also had the effect of blowing out the care list and our practices as well. One concern I did have about how the appointment of a GAL might impact upon the children that I was acting for was in those matters where I already had an established relationship as ILR for the children with the children that I was acting for. I was concerned that by adding a GAL to the mix, it might be a case of having too many cooks, and it might be somewhat overwhelming for the children to have to meet yet another person. Fortunately, the GALs that I've worked with over the course of the year were happy to be guided by me in that regard, and were content to allow me to meet with the kids on their own, sometimes workshopping the discussions that I plan to have with the kids prior to those appointments, and then also providing feedback to the GALs about the views and wishes expressed by the kids after meeting with them.
And people listening along might be wondering why we're sort of delving into this a little bit, but I think it's important to remember that whilst we may not be staring down the barrel of guardians being appointed for children all the time anymore, we do still have guardians that are going to be appointed for the parents that we represent. So I think it is worth me asking you this next question, Kate, which is, what was it like working with guardians? How was it different? What were the challenges? Guardians being appointed for parents is not something we do every day, so any experiences you can share, I think, for practitioners so that they have a bit of a head start for when they have to do this, I think will be really helpful.
Certainly, and while it is the case that we're not necessarily looking down the barrel at future GAL appointments, I still have matters. I've got 5 matters at the moment where GALs continue to have been appointed for the children that I'm acting for. So my work with GALs is certainly going to be continuing for a while. Previously, I'd only ever worked with guardian ad litem in relation to parents, not children, and I gathered that had been the experience of most of the GALs as well. I think that for the more experienced GALs on the panel, they might have experienced some difficulties adjusting to their new role of acting on a best interest basis rather than being an advocate for a parent. And so that they did have that period of adjustment to that change of hats that they were wearing, I suppose. One thing that I've certainly found over the course of the year is that working with gals can be very time consuming. Suddenly every ILR matter that I was involved in involved the appointment of a gal that we would need to arrange conferences with, obtain instructions from, send reporting letters to, and that's in addition to our existing responsibilities as ILR. A lot of the gals that came on board this year as well were very new to the care jurisdiction and unfamiliar with care matters and the manner in which they progress through the court. So part of our role also involved educating the gals about the jurisdiction generally. Some of the gals that I've worked with have been very proactive and want to be very heavily involved in every aspect of a case, while some other gals are more content to sit back and be guided by the ILR. So that also meant that there was a bit of inconsistency across my matters, and I never really knew what to expect when a gal came on board for a matter. A concern that I did have going in was that if gals were appointed in my existing matters and the guardian formed a different view about what was in the best interests of the child, that was inconsistent with the manner in which I'd been conducting the case up to that point, I was concerned that a conflict might arise. Unfortunately, though, that didn't occur, and I have found over the course of my matters that the views held by the guardians have either been generally consistent with my own, or for the most part, the guardian ad litems have been happy to be guided by my advice as well.
So just picking up on what you've said there, Kate, thinking about a guardian and their role in terms of stepping into the shoes of the client. When you're saying that you write letters to them, you have to give them advice, you have to meet with them, that they didn't really have a good understanding of the care and protection jurisdiction, that's sounding like a client, a parent perhaps as well. So is it right to say that there are a lot of similarities in terms of what you have to do with a guardian as there are with representing a parent that's finding their way through what can be a complicated system?
I think that's definitely the case, and obviously their experience is different to being a parent involved in a care matter who is also going through the stress and the trauma of having a child removed or assumed into care. But yes, it suddenly felt like all of my ILR matters were also parent matters as well, in terms of the type of work that was involved, and it certainly added to our already heavy workloads in terms of those aspects.
And so what happens next is it doesn't really assist in the sense that because of the amount of orders that were made, we started to see a real backlog of matters with the Guardian Ad Litem panel only having 8 guardians there and just unable to meet the huge demand. So Legal Aid New South Wales in April took some pretty significant steps to have 15 of our in-house social workers appointed to the panel to try and assist with the backlog. And Jennifer, that's where you come in. You are currently appointed as a Guardian Ad Litem to the panel. I'm interested if you can maybe share some experiences with those listening at home.
Yes, I think that picking up on Katie's point there, the bonus that Legal Aid had was those 15 workers were all very, very skilled social workers, highly qualified, very experienced workers. And although perhaps didn't have that experience of the care and protection system, really had a lot of transferable skills to this work. And overall, I have to say the feedback from those team members is that the Legal Aid ILRs were professional, respectful to work with, and having that kind of dedicated experience all made the difference for them in terms of being able to slide into that role, which was quite different to what they would normally do in terms of their work. And picking up on Katie's point around that, certainly for those in legal aid, there are some social workers who have acted as guardians, certainly as tutors in civil matters as well as other matters. And certainly for them, their experience of what the outset of the role was for them was slightly different. Those with a lot more experience and quite a bit of understanding about the care and protection system certainly fell into that role much easier, felt very comfortable in handing the ILRs the lead role in the matter, whereas others were much more curious and much more wanting to understand and find out about how the system works, I guess. And but certainly the experience was for the whole team was a positive one.
Jennifer, are you able to share some observations maybe that you have made yourself, but also the staff that you supervise, about the jurisdiction itself that might be helpful for practitioners to know?
Yeah, certainly. I think some of the stories that I was hearing back over some of the matters, the experience seemed to be that the DCJ meetings were really kind of meetings of hope that the parents might be able to meet the care needs of their children. And certainly with the addition of the GALs being part of those meetings, they were able to bring a whole lot of points of view, a whole lot of questions, seeking more clarity about some of the issues in those meetings in relation particularly to things like domestic violence and the kind of support those parents might have been given or not given in response to meeting some of those care plan requirements for them. I think in many of the cases, there were challenges around finding safe and appropriate care for children in the long term, and that always raised a concern. And lots of adjournments in matters which made making timely decisions for kids really difficult. And I know that some of the GAL team spoke about that as something that disturbed them, I guess, in terms of that process.
One of the things you also mentioned to me, Jennifer, was about working with clients in a trauma-informed way. Are you able to just expand on that a little bit?
Yeah, certainly the experience of the GALs, particularly some of the workers who work particularly with domestic violence, trauma in their own work, are very well aware of how trauma-informed practice, particularly in care and protection, is so important. And they felt that there was a notable limitation in terms of the court process around that trauma-informed practice, particularly with parents around mental health issues, with historical trauma in their own childhoods. And sometimes there were limited times for parents to be able to respond often to a lot of the interventions and timeframes for those permanency planning policies that were put in. And there were some care and protection concerns requiring long-term therapeutic responses to some of those needs, but the system doesn't always allow for that time to be made. And it was those kinds of points that I guess people were coming back with and talking in relation to that response to trauma, particularly for the parents involved in those matters.
I think that's a really important point to raise. It's an outsider's perspective on something that we do every day, and we're so used to it. We're so used to the adjournments. We're so used to the response times for parents to put on affidavits and things. So I think it's probably just quite helpful to hear that from you, Jennifer. Greg, I'm going to come back to you now, because in case things weren't unsettled enough, we had another decision from the Court of Appeal on the 23rd of April, the decision in Choi. Can you tell us briefly about what spanner was thrown into the works with that decision?
Well, Choi was a decision, an appeal from NCAT, where in proceedings from NCAT, the original order was that a guardian ad litem be appointed. But the legislation is slightly different in that it says a person is to the tribunal may appoint a person to act as a guardian ad litem. And so there was an order made on the understanding that the panel that is similar to the panel under the Children's Court would pick it up. There was a dispute, administrative dispute, as to who would be the person. Initially, the department nominated a person. That person was unavailable. They then nominated another person. That person took the view that because there was ongoing litigation involving the applicant, that the best person to be the guardian ad litem was the first person who was nominated ultimately the Court of Appeal took the view that you had to nominate a person. So it had to be a person, whether it be Gregory Moore or whoever. So that was the issue in respect of that. Now, I understand, I've never been involved in proceedings in the Children's Court, but I understand what flows from that is when you appoint a guardian ad litem in the Children's Court, well, is there a discretion in the court to vet who is the person, or at least be satisfied that that person has got the appropriate skills? Now, if you think about it in terms of a tutor being appointed for a young person or person with a disability under the UCPR rules, the court always has to be satisfied that that person has got the skills, or that that person has no conflict of interest, that person is willing to undertake that role. So that's what happened in Choi, as to it was sent back to the tribunal to make the appointment.
And so the flow-on effect on the ground for practitioners really just down that south coast was that the practice of making, I guess, what could be described is an order at large for the appointment of somebody from the panel, was that the court then had to flag that they wanted to make the order and wait for the panel to nominate somebody in particular. So it was delay upon delay. I can see, Kate, that you're nodding your head, so I'm going to take that as agreement with what I've just said. So not helpful in the context of what was already going on. But we get to June, we get to the 23rd of June, and we have the Families, Communities and Disability Service Miscellaneous Amendment Act 2021, where Section 98(2)A was amended. And essentially when that act was introduced to Parliament, there were some comments about the fact that this amendment was being introduced to address the very issues that had been raised by GR, and also as a flow-on effect in Re Oliver as well. So while that immediate and most pressing issue was resolved in June, not quite so, really. There are still some outstanding issues that are really, really important for practitioners to know about that remain unresolved. So, Greg, I'm going to come back to you. The Court of Appeal decision that was delivered on the 30th of July, which is GR and also BW, can you tell the listeners what that judgment tells us?
Well, both matters went up to the Court of Appeal. The Re Oliver went up to the Court of Appeal because the department sought judicial review. Justice Sakar then referred it up to the Court of Appeal so it could be dealt with at the same time as the appeal against his decision. So there were three questions that were sent up in the Oliver matter. Is the child automatically a party to the proceedings in the Children's Court in this matter? Two, if the answer to question one is no, is the child a necessary party to the proceedings in the Children's Court in this matter? And then the third one is, if the child is a party and the Children's Court is of the opinion that the child is incapable of giving proper instructions, does 98(2)A require the Children's Court to appoint a guardian ad litem or direct the Children's Court to consider the factors in Section 100? So what ultimately the Court of Appeal decided is that questions 1 and 2, the party issue, they didn't have to decide that. Question 2, I suppose that's okay, because I would have thought if you answered the child is a party, I'm not sure why you'd then go on to say, if no, is the child necessary a party? And then they decided in 3 that 98(2)A was not mandatory, but His Honour Justice Sakar erred. So you're still left with no resolution of party. As I understand it, legal aid came into the Oliver matter as amicus, and they took a different view to the critical issue of whether the child's a party to the Secretary. As I understand it, the Secretary said, no, the child's not a party, whereas the legal aid took the view that the child was a party. And I don't really talk about in the judgment the different submissions as to why you're a party or why you're not a party, but that's the real outstanding issue. Where that leads you is in certain provisions of the Care Act, you've got to be a party to do something. Now, the first time, if you look at the right of appeal, the right of an appeal is to a party. But there is, if you look then at the role of a child's representative, one of the roles of a child's representative is to lodge an appeal. If you go through certain parts of the Act, it doesn't really matter too much because they're not confined to a party. There's certain provisions of the Act that Section 90, for example, allows child or young person to bring applications. 86 talks about child or young persons, but there are certain provisions of the Act that just limit it to a party. So if you're acting for a child and you want to bring that sort of application, you're going to have to convince a court that you're a party. There are other legislation, the domestic violence provisions that allows the Children's Court to amend a domestic violence order, allows a party to the care proceedings to be a party to those proceedings. And that's where you might get caught as well. That's the real reason why there's this outstanding issue. Whether it'll play out dramatically in the future, maybe not.
Well, I can tell you, Greg, what I wonder is, are we going to be in a similar situation as we were with Re Oliver, where we were waiting really for it to become an issue? It could be raised, I guess, by anybody at any time and in any location, really, couldn't it? That somebody, in the context of an application being brought, might say, I'm not sure you can bring this.
Yeah, that's right. That's first basis, first principles. Where do you get the right to bring this? And if it's confined to a party, then you're in the territory that you're arguing in the Court of Appeal. Court of Appeal took the view that it wasn't an appropriate vehicle to answer that question. So it's left for another day.
And I think from Legal Aid's perspective, for those panel lawyers that are listening in today, we want to support you with these issues, as we have tried our best to do with the GR issues as well. If this comes up in a matter that you have, if you would like some assistance from us, we would be more than happy to provide that. So do reach out if this comes up to me, and we'd be happy to provide you with some support. We obviously did participate in the Court of Appeal proceedings, so hopefully we can provide some helpful insights into some of the things that you might wish to raise with the court. Now, I'm conscious of the time, and I do want to have some time left to answer a few questions, but I just wanted to ask this question of you all, I guess. Despite the fact that the law has been reformed, there is still the ability under the Act to have a guardian appointed for a child. Has anybody got any thoughts about when that might actually be appropriate? Where is the place for guardians for children?
Well, look, I struggle to come to think of facts that would warrant it. I think the Court of Appeal talked about you might need a guardian ad litem with special expertise if the child was suffering from disabilities, etc., that sort of thing. So that would be the application. I mean, I noticed, Katie, you referred to a decision of Judge Marion some time ago, where the child's lawyer in those proceedings sought the appointment of a guardian ad litem. And His Honour dismissed that application. He spoke about the reference to special circumstances and where that what might amount to special circumstances. The argument seemed to be that the children were Indigenous and therefore there was a special reason for a guardian ad litem to be appointed in those circumstances. His Honour said, well, just that by itself is not enough. But I just wonder, if you look at GR itself, GR must have been pretty close to a child with, or a young person with special needs that required the appointment of a guardian ad litem. But other than those sorts of issues, I just struggle to find a basis to bring the application. Maybe I'm just sort of so used to there being no guardian ad litem for children that my mind's a bit closed on it.
Well, certainly when I reached out to the in-house practice to ask for experiences of people working with guardians for children, I can tell you I didn't receive a lot of responses. So I think it's very much not the trend at all. So anyway, it's an interesting question to pose, I think. Now we've just got a few more minutes for questions. I'm just going to have a quick look on my computer screen to see what questions I might like to pose to you. Okay, there's some really tricky questions here that people have. Greg, I'm going to put this one to you and feel free to do the Tony Jones or perhaps take this on notice type response if you'd like to. This one's from Peter Brain. Where a case is finalised with a guardian ad litem in place, what is the status of the guardian in the district court given the legislative changes?
What, on appeal? So was if the guardian's a party to the district court proceedings, you'd have to join them under the rules as a party. Or you might then just have to go through and have the guardian appointed again. I think that's about it.
Appointed
as much as I can help.
Formally appointed in those proceedings as well.
Yeah, because you often, you used to get arguments in the district court sometimes about the appointment of children's lawyers. Someone to turn up automatically thinking that because they've been appointed in the children's court, they're appointed in the district court, and some judges, trial judges, take the view, no, well, when did you get appointed? Where were you? Who appointed you? Why are you here? Particularly if it's changed, if someone as an agent comes in, there's been some cases where a judge goes, well, I'm not hearing from you. You're not the child's lawyer that was appointed. I want X tell X to get here tomorrow.
All right, I'm just having a look at some of the other questions. Greg, would you like to take a question from the President? I think the answer's got to be yes.
I don't think I've got any choices about that.
I think you're right about that. Does the decision of Children's Court Magistrate Williams that children are automatically parties continue to apply?
Yeah, well, because the Court of Appeal didn't deal with it. So, whether other magistrates choose to follow it or not is another thing. Because, as the President told me once when I was relying on a district court decision of another judge, that he didn't have to follow it, and he was more senior to that district court judge in any event. But I don't think the Court of Appeal, the Court of Appeal didn't deal with the issue of party.
That's exactly right.
That's right. Yeah.
I'm just going to have a look. So Jenny Wong has a question, and Kate, this is probably one for you, I think, and you as well, Greg. COVID lockdowns are impacting on parents' ability to engage restoration services, and some cases are halting completely. Can you see this unduly delaying final orders?
I think that the COVID lockdowns and the COVID restrictions are having significant impacts on lots of different aspects of matters before the court, whether it's engaging with restoration support services. I have a matter at the moment where I act for a young mum that DCJ has made a referral to the Red Cross Young Parents Program, but it's unclear given the current COVID restrictions if that referral will be able to be accepted and when. I think that it's also having an impact on conducting of parenting capacity assessments and the like. So I think as well as arrangements for family time in certain matters. So I think that yes, I think that delays may flow as a result, and I think that it's having, unfortunately, an impact on a lot of different aspects of the matters that are currently before the court.
Yep, I think that's right, Kate. Now I'm just going to sort of take this almost as a comment because we've literally got 30 seconds left. For our culturally and linguistically diverse parents, children who require guardians, how can we ensure the guardian understands the nuances of client's culture is appointed? So really the gist of that question is, how can we make sure a guardian has the appropriate understanding of the cultural considerations that are relevant, I guess, to this parent or child? And that is something that came up in our discussions with the panel around particularly Aboriginal and Torres Strait Islander children, and the importance of making sure that guardians perhaps are either Aboriginal or Torres Strait Islander themselves, or making sure that there is some level of recruitment around guardians that have different cultural backgrounds and different experiences. So that's a good, I think that's a good point to land on, and something that we can certainly feed back to the panel. I'd like to thank you all. Greg, Jennifer, Kate, thank you so much for joining us. And for those listening along at home, please now feel free to join us for either session C or session D. Thank you.